Okay, well, thanks everyone for coming. We're getting started. My name is Rob. I organize Idea to IPO. We've been doing events in Silicon Valley for many years. We hold events multiple times a week from San Jose to San Francisco. We always have a busy calendar of events. I'd like to highlight two events that are coming up. This Thursday, September 21st, Early Stage Valuation Workshop, What is Your Startup Worth? Featuring Jeff Faust, certified valuation expert. He's going to be able to tell you what your startup is worth, or maybe what it's not worth. That's in Mountain View, again, this Thursday, July 21st at Tech Code. Further on down the line, Thursday, October 26th, we have a panel discussion, latest innovations in fintech. We'll have a great panel in place, so check that out. At the College of San Mateo, all the details are on our website, ideatoipo.com. We were launched officially on February 1st, 2010. At that time, we had no members and no events on our calendar. At this stage, we have over 55,000 members among all our meetup groups in the Bay Area. We've completed over 1,789 events. By any standard, by any measure, we're the most active, most prolific startup event organization in Silicon Valley, bar none. Thank you. Well, I appreciate the enthusiasm tonight, but I'll take whatever I can get. Our mission is to promote entrepreneurship, support entrepreneurs, build community, and provide value in the Silicon Valley startup ecosystem. To that end, we provide content that is practical, actionable, and relevant, stuff that you can actually use to succeed as entrepreneurs. We believe in building community because Silicon Valley is an aspirational ecosystem that attracts people from all over the world who come here to do great things. Who here is not originally from Silicon Valley? Who here was born and raised in Silicon Valley? All two of you. Well, welcome, guys. So whether you were born and raised in Silicon Valley or you just arrived last night, it is important for us to provide multiple channels for you to meet people, build relationships, and grow your network. So in addition to the multiple content-oriented events that we have throughout the week, we also have social events on Friday nights every few weeks. The next one we're having is Friday the 22nd, TGIF. Thank God it's Friday. It's a mixer at the Hyatt Regency Santa Clara. It's hosted by CJ Terrell, one of our team members. So check that out. You're all welcome. I know most of you guys are busy on Friday nights, but just in case, we have an option for you. With regard to value, it is important that we provide value at each and every one of our events. Not just value for your money, which is important because we know many entrepreneurs are struggling financially. So we make sure our events are affordable, and if you cannot afford the cover charge for whatever reason, please come see me. We're always looking for team members to help us out at our events, and all our team members can attend all of our events for free, and there are lots of other benefits as well. And we try and have a decent buffet meal at each and every one of our events. Is this a decent buffet meal? I'm glad somebody appreciates it. But anyway, we try our best. More importantly, at each and every one of our events, it's important that we provide value for your time, which is your most valuable resource. Anyone here getting any younger? Besides Roger? Anyway. When you invest your valuable time to come to our events, it's important for us that we provide value and that you're able to maximize your ROI. We have many partners that help us do what we do: law firms, venture capital firms, angel investor groups, incubators, accelerators, colleges, universities, lots of other players in Silicon Valley. Tonight, we're grateful to Datati Digital Marketing for hosting us at this beautiful venue. Is this a beautiful venue? Yeah. So I'd like to have Philip, the CEO of Datati Digital Marketing, come up and say a few words. Let's hear it for Philip.
Thanks, Rob. As Rob said, I'm the CEO of Datati. We're a digital marketing agency. We focus on helping small and mid-sized businesses grow their business through assisting with their marketing strategies, websites, web content. We also help do implementation of marketing automation tools. So if anybody has any questions about that, please come talk to me after the event. Thanks.
A couple of our other partners are here tonight. I also would like to have them come up and say a few words. Let's hear it for Frank and Pure Storage. Applause.
Thank you, Rob. Hello, guys. I will be your cameraman tonight, so make sure you smile at me when you see me. And I also do some side projects like mechanical design and quick sample. If you have a startup, want to do some sample or stuff, please come to me, and I will be right over the corner after this meeting. Thank you.
So our local mission in Silicon Valley is to help entrepreneurs here. Our global mission is to democratize entrepreneurship and innovation all around the world. To that end, we have a robust YouTube channel, youtube.com/idea-to-IPO. Please check it out. We have tons of videos. We've documented and archived many, many of our events. And this rich, valuable content is available on demand, anytime, anywhere, totally free of charge. Whether you're in Sunnyvale, Palo Alto, Maui, Moscow, or Timbuktu. And our partner in this endeavor is Tim Jeggers of Jeggers Films, one of the top professional videographers in Silicon Valley. Let's hear it for Tim.
Thank you, Rob. So yeah, I'm Tim. I'm doing the video for the event tonight. You'll be able to see this on the Idea to IPO YouTube channel that we have. I've been doing event video production for about 10 years now. I started doing weddings, I do this, informational video pieces and concerts, all sorts of fun stuff. So if you have any questions about event video production, I'll be around all night. You can find me in the back. And yeah, I'll give it back to Rob and we'll get started. Thank you.
Here's the schedule for the rest of the evening. We're going to have our featured speaker present. Audience members, hold your questions. At 8 o'clock, we're going to take questions from the audience. We're going to set up a mic stand right there. Feel free to go up, ask as many questions as you like. We want to take as many questions as possible. We'll wrap up the formal program at about 8:30. You're welcome to stick around, network, talk to our speaker one-on-one. And ideally, we'd like to close out the event at 9 o'clock. If you have to get up anytime during the formal program to get some food or use the restroom, feel free. It's a pretty informal situation. So without further ado, I'm going to introduce our featured speaker tonight. He is one of the top corporate and startup attorneys in Silicon Valley. Frankly, he's an iconic figure in Silicon Valley. He's at almost every event out there. He's at meetups, conferences, social events. He is Roger Royse. Let's hear it for Roger Royse.
Thanks, Rob. Oh, good, it's on. Thanks, Rob and Idea to IPO. Congratulations on your success. Thank you to Tati for making this space available for us. It's a really, really great space, holds a lot of people. And thank you all for coming out. And of course, to our sponsors who made this possible. So I want you to imagine, well, first of all, how many startup entrepreneurs here in our audience? How many angel investors or VCs? There's always one. There's always that one guy. Oh, this one we got two. Okay. Other service providers like me, accountants, things like that. So what I do in my firm, we're about 30 lawyers, and all we do is technology startups. I got a few venture funds I'll do some stuff with, but for the most part, it's tech startups, and I've been doing it for about 30 some years now. And we always see kind of the same 10 issues come up. So I want you to imagine that you're one of those startup companies that you have your product, your idea, you figured it out, we were out at the bar one night with your friends and you wrote it down on a napkin and you could read it the next morning, so it must have been really good. And you put everything together, you get your team together, you write your code or whatever it is, you do your prototype, you get far enough along, you get an investor that really believes in you, and you even find some mentors and advisors. You actually have a winning idea, okay? You don't want that idea to get stopped in its tracks because of a legal issue. And that's what I see all the time, and that's what I want us to get ahead of here tonight in this program. Now, I've been doing this presentation for a very long time, And in fact, I wrote a book about it about 5 years ago. The name of the book is Dead on Arrival: How to Avoid the Legal Mistakes That Could Kill Your Startup. And you can have a copy of that book if you go on Amazon and buy one. Or if you give me a card before we leave tonight, I'll send you an electronic copy, and it goes through everything I'm going to talk about. All right? Because I got to tell you something. You need to know this. You cannot rely on your lawyer to know this. You got to know what questions to ask. You got to know where you have vulnerabilities. It's kind of like this morning I went and saw a running doctor because my knee's been bothering me. You know, and the thing is that I've seen so many doctors about this over the years, sports doctors, and if you don't ask them exactly the right question, they might completely miss it. You know, it turned out just to be because I pronate just a little bit, and it's because my tendons are really tight, so there's a stretch for that. No one ever told me that, you know. But if I had done a little bit of reading myself, I could have just asked them. I could just ask the right questions. Kind of the same with legal. You kind of have to know the questions to ask, because people might not tell you that you should have vesting for all your founders. All right, they might not tell you about some of the other ways that you can split up equity rather than just equally. They might not tell you about IP, or you might not know enough questions to ask, so you clarify what the IP is, and you don't end up, getting the wrong intellectual property into your company, slicing and dicing it wrong, or having the wrong sort of protection. We're going to cover all of that at a high level here until 8 o'clock. And again, pick up my book that I will send to you if you want to dive any deeper in this. So my top 10 legal, let's not say legal mistakes. That's just so negative. Let's just say legal issues. Okay, because we're going to get ahead of this. We're not going to make any mistakes. We're going to recognize the issues, make sure we take care of them. So here's one, and this comes up so often, it's why I mention it. A lot of you, don't have to tell me who, you have day jobs, right? And that idea that you're working on, you're doing it at nights and weekends. You're doing it at your own home and not on your employer's facilities. You're doing it on your own time and not on your employer's time. And importantly, and this is kind of tricky, people sometimes get this wrong, the thing you're working on is not the thing your employer hired you to do, right? Something different. It's not their business. Okay? So you're not making any mistakes. You're doing everything right. The people that run into problems with this are the people that are sitting at their desk all day while they're being paid by somebody else typing away. And the problem is that your employer you've signed an agreement when you went to work for your employer. That agreement says that you owe them all of that proprietary information and technology that you develop while you're on the job, developed in the course of employment. There's a form floating around Silicon Valley that some of the biggest firms in this valley use regularly. If you don't have someone like me, read it, which says you assign everything that you come up with while you're employed by them. Fortunately, the California Labor Code says, well, just hold on here, not everything, no matter what that agreement says. You don't assign what you do on your own time, your own facilities, and it's not in the course of your employment, okay? So regardless of what that form says, if you're an employee, I feel pretty comfortable. We'll get you out under the labor code for that stuff that belongs to you. But where people get in trouble is they're sitting at their desk at work and they're working on their side hustle. Don't do your side hustle at work, okay? That's going to create a big problem. It's the number one problem. And when I sit down with a new client, we go through my checklist and we have our interview. It's like the first question I ask. I need to check that box before we go any further. If we can't check that box, we can't go any further. You're done before you start. You might not know about it. It's like getting hacked. You might not know you've been hacked until down the road and you're successful. And then the former employer will pop up and say, wait a minute, that's my thing that you're selling there, you know? Cease and desist. Okay, so that is the issue. Employers' facilities, it's probably the thing that comes up the most often. A lot less now than it used to, because people have gotten really smart in this valley. A lot less around here than it used to. I remember even 10 years ago, people were so dumb about this. You know, they would copy, even lawyers. I know a lawyer who, when he got fired, he quit his job, and he started downloading files, you know, before he quit, because he thought he could just take all those forms with him. The guy's a lawyer, you know, and the law firm's systems for one of the very big law firms. In fact, I just heard this story last week in Chicago. One of the big law firms, they had a system that automatically detected any unusual download activity. And this is before he even announced he was quitting, and it just shut him out of everything immediately. But how embarrassing, huh? Bad record keeping. Yeah, I probably should put this number one, because this really is kind of my, remember that book I told you about, Dead on Arrival? You know, I like to put these issues in the three categories. One, it's not that big a deal, we can fix it. It's going to cost you a little money. You know, category two is that, oh, this is going to be a valuation issue for you. We can't fix it, it's a big risk. It's not going to stop you, but it's going to cost you down the road because your financier or your buyer, when you exit this company, is going to penalize you for it. And thirdly is a dead on arrival issue. So like the slide I just showed you, I mean, that's a dead on arrival issue. If your IP belongs to your employer, you're kind of done. Bad record keeping, this is one we can fix if we get to it early enough and everybody's agreeable and everybody will sign something. So I have this little app on my computer called Facebook. I don't even have heard of it. And I go log on every once in a while for about 12 hours a day, it seems. And I saw somebody posted something. They said, you wouldn't believe it. It says, here I've been helping these guys out, these friends of mine. I hope that person's not in here. These friends of mine, and I've been working under a friend DA, and he sent me this nasty threatening letter saying I have to sign an NDA. And these guys are my friends. And I told him, I won't say what he said, you know, but I'm so offended. They want me to sign an NDA when I was giving them all this free advice, you know. Well, you know, that's a problem. That's an example of bad record keeping, to go back and ask even your friends to sign this stuff. And I'm sure, I know what the NDA said, it was an assignment of technology was probably included, because every investor is going to want that. And now they got a big fight in their hands, and now the guy's offended, and he probably won't sign it. Would have been so easy at the front end just to blame me. Just to say, hey, my lawyer says everybody who touches this company has to sign these documents. So that's bad record keeping, not having contracts. Employment agreements. If you don't have it in writing, you know, it's kind of your word against theirs, right? And their word is always going to be, well, I was promised this and that and the other thing. But where it really becomes, where this can go from an easily fixable mistake to a dead on arrival issue is in equity. That's where I see it come up. And that's where you get together with your friends, your co-founders, and you come to this agreement as to how you're going to split up the company. You have sort of a verbal agreement or an understanding, or maybe you don't, or maybe you think you do. And I've had this happen more than once, where I'll get my two founders come in the room and they've got their handshake deal, and I say, okay, what's the ownership split up? You know, and one says, well, I was thinking 60-40. And the other one says, I was thinking that too. Guess what? They weren't thinking the same thing. You know, and they're done until they resolve that issue. You can't go forward without having, so get in, and it doesn't take much writing for something like that. I can't tell you how many companies that I've started on the back of a napkin. You know, they signed it, they wrote it down. You know, it's pretty good evidence. But that's kind of a big one. Get it in writing, and document the transaction. Now, we're not going to do, I'm not going to give you the back of a napkin if you come to me. We're going to have something a little more formal than that. But the point is that you really have to document these things, because that is the number one issue, is that when comes time, if you wait too long, you start to put things together, the company is successful now, it's got an investor, people's recollections change. And not just ownership, maybe vesting, right? Because everybody, we're going to talk about that in a minute, but well, I'll save that, but there are a lot of provisions other than ownership that need to be documented. You know, we're going to hold questions till 8. Rob likes to do this all at one time. Well, we'll talk about vesting now. So some of you from someplace else, did you move here recently? You all been here a long time? Who's been here more than a year? Oh, okay, well then you know what vesting is, right? Everybody knows it. But for those of you who might not, vesting is the concept that you earn into your shares, that you have to forfeit or sell back at cost the shares that are unvested. So for example, if I have a 3-year vesting schedule, that means at the end of 3 years, all of those shares will be released from any obligation I have to give them back to the company if I leave. But if I leave the employment of the company during the 3 years, I have to give some portion back. So if a 3-year vesting schedule, if I leave after a year, I keep a third and I give 2/3 back. Technically, I sell them back at cost, but it's pretty much giving them back. That's vesting. Used to be a time I had to fight with every company over this. Every set of founders that came in my office, I'd say, you guys should put some vesting restrictions on your shares. And they'd think to themselves, oh, God, why would I want to do that? Whose side are you on anyway? Say, look, I'm not trying to hurt you. I'm just trying to protect each of you from each other. Because if you think about it, you got 3 founders. First of all, one of you is probably going to be gone before you get funded. You just will, just statistically, that's not unlikely. And secondly, you own a big chunk of stock, and that company's going to need that stock back in order to motivate to give it to somebody else to replace you, to incentivize them. And thirdly, people are going to feel pretty unhappy about having to work hard to contribute to a founder who's not here anymore. You need vesting restrictions. So it's something that I don't know if I really even need to have it on this slide anymore, because it's not a battle at all. It's not a discussion. It's not a challenge. It's pretty rare that a company doesn't do this. If it has more than one founder, they are going to unvest. The other thing is the investor is absolutely going to make you do this every time. Even angel investors, even note holders in this valley will want the founders to have an incentive to stick around and a penalty if they leave. So you can just plan on that happening anyway from your investors. So you might as well do it yourself. Now, let's finish this up as long as I'm on the issue. And I kind of go on at length about this. I'm going to walk you through the thought process you're going to have when you get into this. You're going to say, well, okay, that sounds fair. But gee, what happens if you sell this company and it's some sort of deal where we get stock for stock, or maybe you sell and fire me right away because the buyer, they don't want me. But if you sell the company, I should vest in 100% of my shares. So I receive 100% of the consideration on the sale. I don't get some unvested consideration, right? Second thing you're going to think of is, hey, what if there's 3 of us founders? What if 2 of you guys gang up on me and you just kick me out for no reason other than to take my unvested shares back? So if you fire me because for cause, I come to work drunk every day, or I'm always on Facebook, or I'm always texting, okay, good enough. But if you just fire me for no cause, I should get fully vested. So those are the 2 thoughts that are going to cross your mind as a founder being asked to vest. Those are each called a single trigger, right? Where you will end up in this valley, just as a compromise that we all kind of live with now, and we've all accepted, if you're in this valley, if you're on the East Coast, forget it. It's just going to be World War III. You're going to fight over this until somebody gives up. But if you're out here in California, you will probably agree with what we call a double trigger. That means that if the company terminates you, Mr. Founder, or anybody else, consultants, employees, whoever else negotiates this, if the company terminates you without cause, if you're terminated for cause, forget it. You don't get the benefit of this. But if the company terminates you without cause within some period of time, 6 months or a year, of an acquisition, okay, that is a double trigger. Then you fully vest, or you vest in some additional proportion, maybe not fully. The idea being that what we're going to protect you against is this concept that small co really needs me. I'm really important to startup co. I'm not so important to big co that acquires us. So big co acquires us. We do a stock for stock deal. I get this unvested shares for the shares that I had, and they turn around and they say, "What do we need him for? We got all sorts of, coders, designers, CFOs, whatever." So if I get fired for that reason, that's none of my fault. That's a double trigger. I should get some additional vesting. That's where we end up. That's the compromise. Lawyers in this valley understand that. We don't fight so hard to get to that point. We kind of just, all agree and realize it's market and call it a day. But the important thing is you can't start with any of the extremes, either full vesting or no triggers at all. Tax preparation. Business structure you choose. Okay, I was in Chicago last week. I was on a panel speaking to lawyers from all over the country for the business law section. Topic of the panel was choice of entity. And it was me and a bunch of other lawyers who thought that limited liability companies were the best thing ever. And my topic was to tell them why, and I'm a tax lawyer, by the way, was to tell them why a Delaware C Corp was the best choice ever. And we argued for a couple hours over this. The answer to the question is that it's a fact-based determination. There's never going to be just a one-size-fits-all solution. We had a big, long discussion on email, on a listserv about this. I printed out the emails, they're about this high. And there were opinions from lawyers who practice in this area regularly. There were opinions that ranged from, and I'm just going to quote directly, one, you are committing malpractice if you do anything other than an LLC, all the way to, if you are anything other than a Delaware C Corporation, you're going to be viewed as a rube who doesn't know what he's doing. Okay? These are lawyers who practice in the area. Those are the opinions. I can make it a lot simpler than that for you. First of all, it is very kind of factual. But here in the Silicon Valley, what do you think the answer usually is? Delaware C Corp. And now I'll tell you why. Because if you're the kind of company that you either got to go big or go home, right? You either have to, where's my ad tech guy? If you I was just talking to, if you have to just get a lot of money really quickly and get in the market in a big way, so you are either going to get that institutional investment or you're going to go out of business, then you're going to be a Delaware C Corp. And I'll tell you why, because the institutional investment, that's the VC, will almost always, that's what they want to invest in, right? So if that's your only path to success, go big or go home, there's nothing else really, you're going to end up there anyway, right? So you might as well start there. And there's a lot of good reasons. I could talk, I did already, last week I talked for hours about all the, the details, but that's kind of the thing. If that's your solution, you don't really care about all these benefits. And so let me tell you the difference. I got to take a step back. Limited liability companies and S Corps are what we call pass-through entities. There's one level of tax. So if an LLC sells all of its assets and then liquidates in an acquisition, okay, if that's how it exits, the members of the LLC pay one level of tax at capital gains rates. So that's going to be 20% plus 3.8% net investment income tax plus California tax. So say you pay a third tax. If, on the other hand, you're a C corporation and you sell all of your assets and liquidate, you pay two levels of tax. A C corp gets taxed once, then they distribute what's left over up to the shareholders. It's going to be 65% tax by the time you're done. So think of a 20% percentage point difference. A $10 million sale could be $2 million on $10 million. It's real money. It's big money, right? So there's definitely tax advantages if that is the path that you follow. The usual arguments against that are, the biggest one is that we're going to be a C Corp anyway, otherwise we won't have that liquidity event, all right? The other, I guess the other argument is that even if that is not your path, there are some advantages to being a C Corp. One is this thing we call qualified small business stock. It means investors, they can buy the stock. If it's a C Corp, they can, if they hold it for 5 years, they can sell it, and there's a whole bunch of other factors. They get, anyway, the business has to have no more than $50 million of assets. It has to be in certain types of industries, not services business. They get 10 times basis or $10 million, but they exclude their gain. Totally a tax-free transaction for them. It's a big deal for investors. My investors in the audience will tell you that. That's a pretty good benefit. If we can sell our stock, hold for 5 years, sell, and not pay any tax, right? So there are other good reasons for doing that. But the general rule is that if you go big or go home, VC, be a Delaware C, if, on the other hand, you're going to maybe not need venture capital, probably not, you're going to fund through operations, you're going to generate EBITDA and taxable income, you're going to keep that company around for a while, and then maybe you'll sell down the road, well then that one level of tax looks really good because you have the ability to do it. Now here's the problem. Here's why we have so many arguments about this. Most of the companies I work with, if they're on one side or the other, that's pretty obvious, right? A lot of them are in the middle. They don't really know. So I ask them, I say, what's your plan? What's your exit? Are you going to be profitable before you exit? Right? Because my venture backed companies, they never are. They just, rarely. I mean, they don't want to. They want to get. They all read about the Snapchat deal, and they figured out, that it's $1,000 a user. So they want to get eyeballs, onto their site. They don't want to have to charge people, because that works out to $500 an eyeball. And if I get 1 million users, they do the math and say, we don't want revenue, we want users. So who cares about this current income tax thing, right? On the other hand, maybe we don't become the next big thing, but we can still have a real nice business if we don't. That's the hard case. That's the really hard case, right? And my default, I'm in the minority on this around here, not in other parts of the country. My default is to use a pass-through until we know that we're going to be the venture-backed company. Because I can always convert that pass-through down the road. I can always convert the LLC into a corporation. I can't go the other way very easily. So that's, if you don't know, that's where I end up. So I probably do more LLCs and S-Corps than most people. The point is that a little bit of thought ought to go into this decision. I wouldn't do anything knee-jerk in this case. Wage and hour laws. Yeah, this is kind of a tough one because I don't think I've ever seen a startup company that didn't violate California's wage and hour laws. I mean, they're so Byzantine. It's just, just forget about it. I've seen, it's a rare company that I've seen that's managed, to keep track of meals and breaks, and to make sure that you're not paying, that you're paying overtime when you have to. And by the way, I hope your employee doesn't have a personal device and an email that they're using at home, because they should be clocking in and out. I mean, it's really hard to comply with. The big problem for startups is this idea that they can just pay everybody in equity. You can get away with that with founders, because founders are not going to sue the company, they're suing themselves. The less founder-like a person is, the riskier that is, because California and federal law has a minimum wage. The overtime rules can be really complicated. I won't get into that. Let's suffice it to say there's a minimum wage, right, that even founders are entitled to. And that minimum wage has to be, for federal purposes anyway, that minimum wage has to be paid in cash currently. Can't pay it in stock, right? So when you start giving equity to everybody in the company, you are violating these laws. Now, I will tell you as a practical matter, that's just something we live with. The local investment community, they understand it. They understand how ridiculous these laws are. And we just live with that risk. But every once in a while it blows up, and you get in front of the labor commissioner and you're toast, because this is a tough one. People ask me, clients come to me and they say, hey, can I pay my engineer, can I just pay them in stock? I'm just going to give them stock and not cash. And I say, no, you can't do that. It's against the law. And I say, well, we don't have any cash, and we have to hire this guy, so, I got no choice, so tell me it's okay. And I say, I can't tell you it's okay. I know you're going to do it. I know everybody in the Valley does it. I know the investor's going to understand it too, and they're not going to care, but I can't tell you to do it. I was listening to Masters of Scale by Reid Hoffman, the podcast. Does everybody know who that? Have you heard this? If you listen to podcasts, go download Masters of Scale. It's just brilliant. And this last episode of the summer, he walked through several companies, and he called it putting out fires. And he walked through several companies that had to face this decision. Either do the right thing, best practice, things like backing up your files, things like having enough capacity, things like having a support team to take customer calls. It was either you do the best practice, the business stuff, and then you take care of your old customers, and you don't have time for new customers, or you just let those fires burn. You don't put out those fires, you let them burn, and you go off and kind of ignore them so you can scale the business. Every startup does that. Every fast-growing startup I've seen, they do that. They look at these problems, and they say, yeah, I can't do that. That's a problem. I need more customer support people, but I'd rather put the money into marketing. They make these decisions, and they scale. And if they didn't make that sort of decision, they would never scale. I know that. So I'm not going to be impractical. So when a company comes to me and they say, gee, we've got this we should take care of this legal issue. We should have an employee handbook. I don't know. We should do, I don't know, sexual harassment training, because I read that and I heard that at a conference once. You know, I should have this and that and the other thing. I say, you're absolutely right. You should have all these things. I'm going to leave it to you as a business decision. Here's what will happen legally. I'm a lawyer. I can't tell you what will happen. Here's what could happen. I'm just going to give you what could happen. I'll even give you my analysis of the risk of that happening. You as a business person, you go away and you take that and you come back and you just tell me what you want to do. Now, this one could be a big one, though. So we really got to watch this one. Now, little things like founders not getting minimum wage. That's one is regularly ignored. That's a little fire. We'll let that burn, because we're not too worried about founders suing the company, even though they could. One that you can't ignore, though, is classification. And what a lot of startups will do, I don't know if I got a slide on this, but they'll classify their employees as independent contractors, so they don't have to go get benefits, they don't have to get Obamacare. Well, they're not big enough for Obamacare. They don't have to withhold. They don't have to worry about all of these laws that apply to employees. Minimum wage, you don't have to worry about minimum wage. We'll just classify them as contractors. So that's not a fire, that's Chernobyl. That's an issue that will bring a company down, okay? And I've had companies that have been brought down by that issue. You know companies that have been brought down by that issue. Uber had to pay $100 million over that issue, right? Homejoy, $10 million of venture capital, just sayonara, you know, over that issue, right? So that's a Chernobyl issue. So when you get into this kind of stuff, it pays not only to know the law, but to kind of have a little bit of an understanding of what the risk is. So keep that in mind, and make sure when you talk to your lawyer, you know, you explain what the facts are, understand this is the issue you're concerned about, both these two things, wage and hour, overtime, and classification, and then you can make a determination as to how you're going to deal with it. Yikes, IP. So there's so many components to this. My next book goes into great depth about this issue. So when I talk about legal strategy, so let's start with kind of the one basic thing. And this is one of those really big issues. It's that everybody who touches the IP in your company has to give you an assignment. If they're employees, maybe you get a shop right. You know, your investors will want an assignment. If they're consultants or contractors, you have to get a written assignment from them. If you don't get a written assignment from any consultants or contractors that are develop any IP on your behalf, you arguably don't own it. The reason you don't own it is because they arguably have a non-exclusive license to it, which means they can go compete with you. Which means when you go talk to your investors and they say, do you own your IP? You'll have to say, well, not all of it, because there's some guy out there who has a right to use this tool they developed. You know, it's a bad, messy story. You don't want to be there. So that's number one in terms of protecting IP. That's just basic nuts and bolts. Number two, though, and this is a little more subtle and a little more interesting, I got 3 points. The second one is more about your strategy. If you think about IP in the broader sense of the word, like what is it that makes you different from all these other companies? And how are we going to protect that legally? So patents are a really good example, right? Patents, my statutorily protected trade secret. That's what makes me different, and that patent's going to protect me. If that's your strategy, that's a whole different thing, patent strategy, how you're going to do that. But I'm thinking a little more broadly. I'm thinking about the contracts and relationships you're going to enter into. Now, our firm does a lot of work in this field called ag tech, agriculture technology. It's kind of new. There are some issues here. The companies are generally pretty early. There are some issues here we're still starting to sort out. And I'm watching tech companies. The farmers are way more sophisticated than you think about this. So I'm seeing Silicon Valley again and again, Silicon Valley technology companies contracting with farmers or farm service providers and coming back to me with contracts where they basically give away the farm, so to speak. They basically give away all of their IP, right? That's part of the strategy and the protection part. Are you doing licensing or are you a product company? Are you doing part of the stack or the full stack? How are you carving this up in what geographies? There's a real strategic part here. What verticals are you carving this IP up into? What exactly can they do with that product? It's something you really ought to think through. I guess to give you the best example, getting away from agriculture for a minute, this is a better example. I have a client that has a VR product, and the best virtual reality or augmented reality, the best place to launch that, they say, is China, because they're crazy about this stuff in China. So they said, that's great, we're going to launch it in China. So we signed, so they, we got this contract from a big Chinese retailer that's going to take the VR technology. And of course, it was not consistent with the strategy. Now, we ended up assigning a territory in a particular vertical in a particular territory. You get to use this technology for this industry in this market in this geography. Gave it away, but that was totally consistent with our strategy because we know what that's worth compared to the bigger picture. We did not sign the contract they sent over that gave them everything everywhere. But I see that with my ag tech companies a lot. And by the way, if you're doing business with big companies, just expect their contracts to be really one-sided. They just will be. You got to negotiate them. But I think the best place to start is with a strategy. We're going to give away this vertical and test out the technology here. We'll license into that vertical or that industry. Whatever it is, it's best to be strategic. And then the final thing is on the patent strategy. It's so easy now to just have people write patents. You can file provisionals. You get an extra year if you all know how that works, right? Because you're all from Silicon Valley. But when I say patent strategy, I'm thinking about the exit. And I'm thinking, what are we actually going to do with that patent, right? Well, the patent is going to make us very valuable. In fact, there are evaluations and metrics that depend pretty heavily on how many granted patents, issued patents you have. But the better way to approach a patent is by thinking about your acquirer and how those claims might be drafted and how they might view that. And if some of you, you're in businesses, you kind of know who your potential acquirers are, and you kind of read in the papers what they're doing and where they want to go. So draft your claims, right? Get a patent lawyer who understands the market, not just the technology, but understands kind of what you're trying to do as a market matter and who you're making yourself attractive to. So IP strategy. That's a little beyond protection, but it is legal. Trademarks, I call this one out specifically because it's something that just gets screwed up so often and messed up. And also because people, I don't think, really appreciate just how valuable trademarks are. Because when we talk about IP, you think patents. That's what everybody thinks. Oh, IP, that means patents. Well, IP means patents, trademarks, copyrights, trade secrets. Trademarks, let me tell you why it's important. So you're in a company that's developing like a really great, whatever it is, a really cool technology. I think we all acknowledge here that the best technology doesn't necessarily win. It's the best marketed technology that wins. Sometimes it's the first to market that wins. Sometimes it's the fastest technology that's the winner, right? So we all acknowledge that it's not necessarily in the technology, it's going to be in the marketing and in the branding, especially if you're in one of those businesses that's gaining it, if you're Snapchat and you're getting your value from having lots and lots of users. Well, as that's happening, your brand is becoming really, really important because it's creating the biggest asset that's on your balance sheet. It's not that biggest asset that is not on your balance sheet, goodwill. And when you sell the company around here, it wasn't like this 20 years ago, but around here now, when you sell the company, about this much is allocated to hard assets and computers and supplies, and this much is allocated to goodwill. You're selling goodwill. And that goodwill is just, and you know what goodwill is? Technically, it's the expectation that all of those users are going to stay in the company, they're going to come back, and they're going to use your product, and someday they'll pay for it, right? The expectation of future business. Well, all that goodwill really gets impaired if all of a sudden you have to change the name of your company and have to change the mark. And now that thing that they're just totally, that the consumer was totally tied to as recognizing your company and its brand and its value is gone, you lose a lot. You lose a lot of value. So that's why this is so important. Now, that's why it's important. Why is it up here as a legal issue? Why do people mess this up so often? Because it's so easy. You should first do a Google search. You should then do a knockout search at the Patent and Trademark Office. It's not expensive. And you can go find out. You can search the PTO site as to whether your mark or name is being used by somebody else. Now, you don't necessarily have to do that immediately. Most of the companies I work with, they just rebrand anyway right after they get funding. But pretty early in a company's life, before you start building some value, You really want to get this one done. The story I always tell, because it happens again and again, is like, well, not so much anymore because people are wiser to this now, is that the company just goes along for years, building up its brand and its mark, gets into an acquisition agreement, signs the acquisition agreement, they announce the acquisition, we're going to close in 30 days or whenever, and then they come out of the woodwork. Then the potential plaintiffs come out and say, we're shocked to discover that you've been infringing our trademark all these years. You either have to cease and desist, or you can just pay us. And you got 30 days, because that's how long, and we know that, and that's how long it's going to be, before you're closed. And then we're not dealing with you anymore. We're dealing with a buyer who has no real incentive at all to do anything but give us whatever we're asking for. It's like the best, U.S.-based Nigerian scam there is. Talk about ransomware. This is ransom. It's trademark ransom. And it happens again and again, and it's so easy to avoid this. The more egregious case, I have a client who came to me early on after they formed. So this company, they developed, he was just developing apps in a foreign country again and again. He developed 40 of them. 39 of them failed, just fell on their ass. One of them was wildly successful, wildly successful. Last time I checked with him, he had 200 million users. It started to gain success. We put it into a different company. We spun it out. We built it up. We put in some infrastructure. We started to finance it, and word of one of the financings got out. Next thing you know, we get a demand letter, a cease and desist letter, because now they got money from another company that has a remarkably similar mark and is in a very similar business. And at this point, it's now, we've got real value in the mark. The mark was so tied up as a consumer product, it was an app, we just could not change the name. We had to sit down at the table and negotiate with them. And it was a long, arduous process. There was a trademark opposition, there was an appeal, I had to get litigators involved. My God, you don't ever want to have to get litigators involved. You don't have to. They're like nuclear weapons. You just want to shoot them off into the South China Sea. We had to get litigators involved, and eventually we settled on very favorable terms. But we came so close. They could have tanked that company, because the VCs are not going to stand around for that. So, and it was so easy. It would have been so easy. By the way, all this happened before I got involved, but it would have been so easy to avoid that whole argument by just doing a little analysis up front. 409A, everybody now knows what 409A is because it comes up everywhere. Nevertheless, people still mess this up. It's an issue, and it's one that you need to be aware of. And believe it or not, not every law firm is as up on this as you might expect. Once you get outside, in this valley, the lawyers they know this issue extremely well. You get outside this valley, people start to be creative or do unexpected things. So it comes up two ways for you guys. Number one, and it's the one you all hear about, is options, right? You can't grant options without a 409A evaluation. All right, you just can't. I'm just going to lay it out there. Now, you're going to find some people who will say, well, not so fast. I mean, we're so early in evaluate. Jeff Faust is going to be in here next week talking about valuation. And some people will say we're so early and there's nothing to value. And, how's a valuation? How are you even going to value this company? You got no revenue, you got no product, you got no assets. You got my business plan and, us team. But how do you value that, right? So we think we can just put a number on it and run with it. Okay, so I know companies that have done that, and that's not a problem till it's a problem. It'll be a problem if you happen to scale quickly and exit. So this is one of those problems that I had a client about 3-4 years ago. They went from zero to a sale of close to $200 million in 6 months, really fast. They didn't expect that. And before they came to me, they formed a company and gave all other engineers, they were using options as currency. To scale that fast, they had to hire a lot of people really quickly. And they used, instead of granting stock, which is not subject to 409A, they granted options. And they did not get the valuation. And this is not the only time I've seen this happen. This one sticks in my mind because the acquirer came along and said, where's your valuation? You know, we don't care that 6 months, $200 million. I think that those options were worth quite a bit of money 6 months ago. It was only 6 months ago, right? So the solution, the acquirer solution, every single time is going to be cancel those options. We don't want you. We're not taking that liability. Go back and tell all your engineers that those options they thought they had, well, that was just paper for their birdcage. You know, we're not assuming them. Cancel them. It's a really unhappy place to be. Okay, it won't stop your deal, but makes you look bad. So that's 409A. If you don't want to get the 409A valuation, don't grant options. Do something else. We can grant stock. There's one solution. We can do some other benefit. Or what I normally do is we'll issue an offer letter that basically says, we are going, the company is going to grant you an option very soon, as soon as we get an option plan. You'll get this number of shares at the option price established in that plan. That's how you do it as a startup, one of those two ways. So avoid that issue. Second 409A issue that comes up. And just kind of, I've been through this as well. You're working along, you got your side hustle, you're doing it on nights and weekends like I told you, so now you're putting a lot of effort into this that you could be doing something else. And I know how hard it is. I know how hard these startups are. You know, what an effort it is. And you're not getting paid for it. What a drag. You know, and when that investor comes in, you know what, when they put money in your company, they had to pay you for all that deferred, all that salary you didn't take. So here's what we'll do. We'll just start booking deferred salary on a balance sheet. And then I'll get paid when we get funded, okay? Well, that is what you cannot do under 409A, all right? There is a right way to do that, okay? You put the right paper in place, the right bells and whistles, the right contingencies, but if you do that without a written plan, if you just start booking deferred comp because you want to get paid when the company gets funded, you're going to create a problem that will keep you from getting funded. That's one where you have to be careful. Those are the two places I see this one come up. Securities laws. Everybody's thinking about this because we're heard about ICOs and how they're securities, right? So I used to tell so many stories about people who are sitting in prison because they inadvertently violated securities laws. I won't tell you those stories anymore. They're kind of outliers. And it's not your biggest issue right now. I don't think there's anybody in this room who's going to go out and start selling securities without at least seeing a lawyer, maybe. If so, then I will tell you that story. Instead, what I want to talk about is how easy it is to go online and sell securities now, because we've got these very misunderstood exemptions, and we got these new kind of products, and we've got the internet. So the ICO is probably the best example. There is not a day that goes by I don't get a call about an ICO. You know what I mean by ICO? Initial coin offering, or a token offering, some sort of token. The SEC has given us guidance as to when it is a security and when it's more like a Kickstarter advance payment or something. It's an analysis you have to go through. If you get it wrong, you end up giving your buyer a rescission right. You have to give them their money back. You are personally guaranteeing that in most circumstances. So on these new sophisticated sort of offerings, you have to be really careful about it. The other place that's a little tricky is in crowdfunding. There are some excellent sites out there handling crowdfunding, and I only got 5 minutes, so I won't talk a lot about crowdfunding. There's a lot of different kinds. And early on, the very biggest and best sites were getting this wrong. They were getting the rules wrong. They were posting stuff on their site that was wrong. I mean, but now it's kind of sorted itself out, and the sites now are the bigger, better ones are sophisticated, and they got this right. But there are still a lot of sites out there that don't really know what they're doing. I'll just tell you that right now. There are still crowdfunding sites that you should be very, very wary of. I would do background checks on the promoters before you get too involved in them. Because the SEC, it's better under the Trump administration, but they still hate these things. And they're going to be looking for bloody shirts and people to make examples of. So if I were going to do a crowdfunding, I would be very careful about what platform I listed on. Now, even having said that, you still need to know a little bit about securities laws because we don't completely 100% get out of state compliance. There's still a state notice requirement. So there's still stuff for the company to do. And if something goes wrong, it's the company's problem. So you really have to be on top of it if you're going to go that route. So I'm pausing on all this because it's so easy now to sell securities. You got crowdfunding, You've got expanded exemptions to this private offering that we used to have. Now we got ICOs that people are using in new and creative ways. So that's where people get in trouble with securities laws, is doing some of this new, easy, quick stuff without consulting counsel. Wrong type of legal counsel. Okay. Startup lawyers are very multidisciplinary. It's a rare individual that can do it all. We have 30 lawyers in our office, for example. So there's two types of mistakes you can make here. Number one, a lot of people do this, is you need to have somebody who's got some experience in this and at least knows what they don't know. If they don't have experience in it, if they're a really good corporate lawyer, they should know that when there's tax issues or when there's IP issues and they need to bring in a specialist. That's one of those where it's just kind of a bad fit. The other one I see a lot of times that you want to be careful about is that this is like a California gold rush. And there's law firms from all over the world coming into this valley. And the indigenous lawyers here are pretty sharp. We all kind of know how this game is played. The big Boston law firms that are used to doing multi-billion-dollar bond deals are not. So you're going to see a much different approach to the way they do this than startup lawyers. It's kind of like when I first moved to California, I did movie deals in Hollywood. And the way lawyers work down there was completely different than they do anyplace else. And I'd look at something, and I remember I heard this again and again, that's Hollywood. You know, we understand that risk, we just accept that here. Silicon Valley's kind of like that. You know, it's kind of, that's Hollywood. It's just the way we do things here. So you don't want to, the reason I'm pausing on this is because you don't want to be out of market. You know, in Silicon Valley, market is just so important to people. It's, the VCs here are spoiled. They've got, you know, they're spoiled as the women, you know, because there's so many more guys. The VCs here are spoiled because there's so many startup companies, all right? And they don't have to screw around with anything that looks at all unusual. So you don't want to be out of market when you go talk to a VC. And part of what you want out of good lawyers is not only to protect you on all these legal issues, but to be able to tell you what is market, you know, and what risks people take, and what some of the other standards and metrics are that companies are measured by. So that's why I pause on that one. So let me just buzz back through here, see if there's anything else that I want to mention. These are my top 10 legal issues. You know, I'm going to add one more and make an 11 here since I've got 1 minute left that I'm just seeing come up again and again, and it's all around cybersecurity. Like I said, I just came from the business law section meetings, and that's all we're talking about now as lawyers, is companies getting taken down because of cybersecurity. And this Equifax breach, data breach, if you've been following what people are saying about that, they're not too happy with them, right? They're just not too cool with that, and everybody's armchair quarterbacking and second guessing what they should have done. I'm going to add an 11 on here that you companies, it's so easy to gather a lot of data, and California, you should know, is different about data than 48 other states right now anyway. California does have a data privacy law. California does have standards in place. It has rules you have to follow. It has things that have to be in your terms and conditions if you're collecting personally identifiable data. And almost every company I work with is. And this is not one place where you want to pinch pennies. A lot of people say, I'm going to copy my terms and conditions from Yahoo's website. I'm going to change Yahoo and put my name in wherever it appears and put it up on my website. Well, you better be really careful because California does legislate your privacy policies and what has to be in it and what you have to do if you're collecting personally identifiable information. I'm seeing this as an issue come up more and more, so I'm going to add that as my number 11. So with that, I'm at 8 o'clock, and Rob says we can take questions. Yes, sir. Oh, sorry, Rob wants to talk.
So we have this mic stand set up. So if you have a question, walk up to the mic, ask away, and we want to do this as efficiently as possible and get in as many questions as possible. Go ahead.
So you told about record keeping. Do we have to keep the originals of every record, or is digital copies enough?
I mean copies when I say record. What I mean by record keeping is just having a record. to start with. I wasn't really referring to how long do you keep it. I mean, I've got to, I actually have a whole chart of how long you're supposed to hang on to records of everything, like your tax returns, how many years, these sorts of, but most people don't get there in the first place. You got to have the record. And then once you have it, I'm not so concerned about original copies. I mean, even courts now will accept photocopies because the technology is good enough, and they'll accept electronic signatures for most cases, or sometimes not. But there are some documents you want to have an original, and how long you keep it depends on the document. If it's a will and a trust, you keep it forever, and it's got to be an original, right? Because that's what courts take. If it's a stock purchase agreement, you want a copy, but as long as the company's around. Other documents, in fact, remember what I was saying about data privacy? You should have a protocol that actually purges some documents. That's just part of what you want to do is good, I guess, cyber hygiene. So the answer is it depends. Yes, sir.
Hi, this is Rahul. Thanks a lot for the presentation. I have one question on the labor laws you mentioned on the federal and state side. Number one is, what is the definition of founder? Someone can do 2% or 3% and work on that aspect and still avoid this legal issue from federal and state side?
So here's the thing, and that's a good question. It comes up a lot, and there's no real technical legal definition I can point to. It's more of a fuzzy standard. Think of a partner in a partnership. So I can't say anybody who owns more than this is one of those I know it when I see it sort of standards. And there is a founder's exemption, but not for state law, right? So because there's two different sets of minimum wage rules. There's a federal minimum wage and a state minimum wage. So you can get out of the federal, but not out of the state. You still are obligated to pay it. The thing we all kind of rely on is the fact that if somebody is a big owner of the company, they're not going to sue the company because they're suing themselves in effect. But that's kind of that's Hollywood.
No, I mean to say is someone owns, let's say, 2 or 3% of the
They're not a
company.
founder. They're not a founder.
The founder is a terminology. But I mean to say from the
I
labor
shouldn't say
laws
founder. I should say a major participant. That's managerial. They make decisions. They own a significant stake in the company. All the things you kind of look for, like in a partner, really.
One more question is, when you pay out contractors, as a startup, you have certain cash numbers, but when, let's say, can you structure in a way where you pay, let's say, 80% in cash and rest 20% equity? That's still not, that still should be okay because it's not like...
You just need to clear the minimum wage. So as long as your 80% cash clears the minimum wage, you can do that.
Yeah.
Now remember, they're being taxed on that equity as though it's cash, so you would never do it that way. There's other ways to get there, but for this purpose, yeah, minimum wage has to be paid currently and in cash.
And everything else can be structured in equity or other things. But,
Yeah.
thank you.
Hi, Roger. Great presentation. Mark Stoner. So we just formed about 6 weeks ago a Delaware C Corporation. So I've offered 4 advisors 0.25%. So how do we, and it's for a 24-month vesting, and we can let them go in whatever, 30 days notice if they're not active, whatever. The question is really, how do you kind of give people skin in the game without kind of being too tied to them if they're not active or they're gone? How do you reward people?
So the question is, how do we compensate our advisors, right, for a newly formed startup? So you just formed recently, so no valuation, I assume. So we don't want to do options because that's going to get us in trouble. But if these advisors, what you can do is you can do stock grants. That avoids this 409A problem. And the stock can be subject to vesting. So if they don't perform, you'll get the stock back. A couple of things about that. If the advisors are not accredited investors, most of your advisors will be. You know what I mean by accredited? They make more than $200,000 a year for this year and the past 2 years, or $300,000 jointly, or they have a net worth of $1 million excluding their primary residence. So if they're rich by 1933 standards, then they're accredited, so we don't have to worry about them. If they're not, we got to find some other securities law exemption to get the stock to them. It can be a little tricky sometimes. There's ways to do it, but we have to think about it. So let's say that your advisors are accredited, because most of them are, and you're going to give them stock. Then the question is, what you just said, How do I hold their feet to the fire? I mean, they're not coming into work every day. How do I know when they quit working and they stop vesting? I can't really put that monthly 3-month vesting on that, 3-year vesting monthly. Well, the way we do it with advisors is typically the standard in this valley is 2 years. First of all, is a vesting period. Typically you see 3 for founders, you see anywhere from 3 to 5 for everybody else. 2 years for advisors. The reason why is that your advisor should be pretty much used up by then, right? Whatever they're advising you on, you're going to be a different company in 2 years, right? So whatever they're going to do, you're going to soak the value out of them. Maybe they're going to find you money, you know, maybe they're going to help you with marketing or get you that first big customer. I'm an advisor in a bunch of companies, and I know 2 years from now, you know, whatever I'm doing for them, they'll have someone else doing. So 2 years is typically the vesting schedule, but then here's the important part. We tie that to metrics and milestones. You vest in your first 25% when you get me this first customer that does this or whatever. Or you vest when the code gets to this place, or we get this functionality, or whatever the milestone is. If you tie it to milestones, then you don't have to worry about getting into the argument, because I hear that all the time, like, oh man, my advisor, he took the stock and he didn't do anything. He just sat there for 2 years. Can I fire him now, retroactively?
And then what about options versus converting it to a convertible note? What's the relationship of those?
Okay, so there are some people that want to do that, and I've done that too. I don't like to because it's complicated, but what he's talking about is, let's say we pay our advisors in notes, right? Just give them convertible notes. So there's good authority that the note, if it's just an unsecured promise to pay, that they're not going to have taxable income on grant of the note. They will when they exercise it, and you might have a 409A issue if those advisors are very employee-like. We have to run that gauntlet. But when they do exercise then, when they do take the note and either get repaid the note or turn it into cash or into stock, now they have ordinary income equal to the value of the stock. They don't have cash, they got stock, and they got taxable income. They got to pay tax on that. It's not a very good solution for them. I think I would rather take the stock now at this super low value than take the stock later at this high taxable value. So I don't really like that solution, but I have used it sometimes.
Okay, thanks.
Yep. Hello.
Hi, thank you for your presentation today. My question is actually related to the last point that you made, the one that isn't on these slides about data. It makes sense that you have to have your kind of things lined up when you're getting personally identifiable information. But what happens when you're not doing that, but you're getting data kind of in bulk, maybe through web crawling or something like that? So what happens?
When you're getting what?
When you're getting data through web crawling, for example.
Mm-hmm.
So what kind of law applies there? I mean, is it just okay to use something off of Google?
No. So where it comes up, I've got a lot of clients that their product is to go do web crawling and go on somebody else's site and harvest from their site. And the problem is not so much legal as that you're violating the terms and conditions of the site. So they can kick you out and ban you forever, and some sites will do that. LinkedIn will do that. So it's a violation of terms and conditions. Is it illegal? So now we're getting into trade secret law. And if what they're managing to access is trade secret, then yeah, they could be violating our Uniform Trade Secrets Act. But that's unlikely. If it's just a web crawler and it's publicly available, it's probably not a trade secret. So I would worry more about the contractual restrictions than anything else. But then once they get the data, now they've got a consumer's personally identifiable data. Now they've, what?
No, that's not what I'm thinking.
Okay.
There's no personally identifiable information.
Oh, okay, well then it's a matter of terms and conditions of the websites.
And there is no privacy-related laws that actually...
It's not private. They gathered
not
it
private
right off a
anymore.
website, yeah.
Okay, it's just off of... Okay, thank you.
Thank you, Mr. Royse. I have a general question about the right of first refusal and investors that insist on that, and when they start to use it to, I guess the perception is detrimentally hurt the company in that they won't allow other investors to invest.
So you have an investor, so it's really, is it a right of first refusal or a right to maintain? Do they actually have a preemptive right to take any security that the company sells? So let's talk about venture capital terms a minute. So normally what you see, and that's a really good point, in finance, and that's why I love California. We all know what the market is here. Financial investors will not ask for a right of first refusal because as a company, you don't want to give that to them. The reason why is because it chills all the other investors, the later investors. Like, you know what I mean by right of first refusal? Or it's where before the company can sell a next round of securities, they have to offer them to the first investor, right? So if I'm a new investor and I see you have that right, I say, well, why am I going to do all this due diligence on your company if I'm just going to get the deal taken away from me by your existing investors? So it chills follow-on investment. So we don't see that for financial investors here. Strategic investors always ask for that, and we don't give that to them. Instead, we give them what we call a right of first look. But getting back to your financial investor, what you see in term sheets now is what we call a right to maintain. So it's sort of like, okay, Mr. Investor, I'm not going to let you have a right of first refusal. However, we'll give you a right to maintain your percentage interest, or a right to participate. So you can participate in any follow-on financing that we do, because that way we can at least go out and assure these other new investors that they're not going to get the deal pulled from them at the last minute. So that's the standard. If you've actually got a right of first refusal, then yeah, you've got a big problem. What would I do to get around it? Are they in California?
No, it's in New York.
That's the worst possible place you could be for this issue. See, in California, we've got this expansive idea of minority unfairness doctrine, right? That where shareholders can actually be sued for violating their fiduciary duties to other shareholders who even thought they had such things. In California, welcome to California, there is that possibility. So there might be and plus we got an unfair trade practice. So you get a sharp litigator and they'll start coming up with all sorts of theories why this is being used solely to oppress the minority shareholders. You get outside of the state, people act a little bit more rationally. They enforce the documents as they're written. Good luck with that.
Thank you.
Hi, the question is about IP protection.
Mm-hmm.
Would you elaborate a bit on what are the steps and at what stage and timing in the engagement, whether it's with the contractors or advisors or consultants and such? And so that's first of all. Second is the tools to make sure the IPs are actually protected during the process of engagements.
IP is so complicated. I'll just tell you, it's a rare lawyer that just finally kind of sees this, clearly. So you just ask a mouthful. So let's go through a few of these points. So number one, at what stage, before that contractor touches anything proprietary or creates anything for you, you better have an agreement that defines pretty clearly what the company owns. And you talked about tools. So what we want the agreement to say is that everything they do for you relating to your company belongs to the company, except stuff they schedule. They say, look, I brought this with me to the company. These are my proprietary tools. Okay, put that on a schedule. We won't fight about that. You can keep your tools. And stuff that they did that's unrelated, stuff that they come up with that has nothing to do with their engagement. Now, the trouble is, there's this kind of sloppiness out there where, and not to over-lawyer things, but there's this sloppiness where the company says, you know what, and I see a lot of company counsel do this, they just draft the clause really broadly. You assign to us everything while during the term of this agreement. And sometimes you see a contractor that'll just say, yeah, okay, I'll sign it, because I'm not going to do anything else. And then you get into the agreement, and maybe there's a dispute because he did something that didn't relate to the engagement. He's not an employee, so he's not covered by the labor code. That's an agreement that's bad for both parties because he's going to challenge the agreement and say, well, we couldn't possibly have meant that. We couldn't possibly have meant that I give you everything. and the company's going to, so the company's going to be in a bad place. He's in a bad place because he signed it, you know, even though he is in California, he did sign it, so a court might actually enforce it. So that's why I say it's important to fill out that schedule that says, what are you carving out? You know, what tools? What is it that you think belongs to you that the company is not going to get? Was there another part to that question? I forgot.
And some of the tools. So, in other words, the NDA probably is the first in the engagement, I would assume, and then later on is the contracts and things like that. So, the NDA, when to use it, and between the NDA and the actual schedule, which is a great point. Thank you. Is there something else?
Yeah, people misuse NDAs. An NDA doesn't typically, it could, but a typical NDA doesn't assign the IP. The NDA is supposed to be used just so people will keep information confidential.
Right.
So they're going to evaluate the business opportunity and keep it confidential.
Right.
You want a different sort of agreement. You want an NDA that actually has assignment language, which I see a lot of, but more typically it'll be in the consulting agreement. Because you're going to have an agreement as to how much you're going to pay the guy, you know, when they're going to get paid, what the deliverable is, all that stuff. That's where you would typically see the assignment language.
Okay, so just to clarify, agreed that to own the IP, it needs an actual contractual agreement. How about just, because at first you engage with a few of the potential consultants or contractors. At that stage, even during the negotiation of that contract, should there be NDA into place or some other things to make sure whatever is discussed, whether the actual agreement is signed or not, the whole thing is protected?
You can try. I mean, if you're disclosing confidential information, I'm not going to tell you not to have an NDA. I will tell you that some people are very wary of signing those here.
Right. So that's why I'm looking for your advice to see where the...
Every company has a standard NDA. If you're going to disclose, if you're going to open a kimono, you know, you won't get investors to do this, but you want your service providers to sign an NDA so they can evaluate, and they should be willing to do that. And then you're right. Then you move on to the next document, which is a consulting agreement with the assignment language, if that's what you mean.
Okay. Thank you.
Okay.
Yes, thank you for a very interesting presentation. I have a question about Delaware setup. From what I understand is that there is a lot of tax benefits if the setup fits Delaware C Corporation. But what laws does the company actually have to follow apart from the tax bit? You know, regarding privacy laws, all kinds of. Is it where the operation is actually happening?
Yes. So here's how it works. We use Delaware C corporations usually for startups, not because we love Delaware. I don't think I've even been there. But 90% of the companies I form aren't under what Delaware law. It's because we want the benefit of their laws. And Delaware is not going to tax you unless you are actually doing business there. So you got to have an office there or employees or enough market share to have nexus. So you're going to pay like there's a fee, there's a franchise fee that you got to pay based on capital, et cetera. So there's these small, and you got to pay the Secretary of State another fee. So there are these small fees you pay, but you're not paying taxes in Delaware, and you're only subject to as much of their corporate law that relates to the internal governance of the entity. That's why we're there, because they're why do we choose Delaware? Why do VCs love Delaware, by the way? A couple of reasons. The law is very clear. Delaware courts are not like California courts. They will actually enforce the law as it's written, not as they wished it would be. But also, Delaware is very clear that it gives the shareholder some flexibility in how they define the rights and obligations of the parties. And I won't get too far into it, but there's this thing called class voting that you can abrogate in Delaware. So for example, here in California Corporation, the founder, some decisions require the vote of each class. That's California law. You just can't get rid of it. So you want to sell the company, and the VCs can own 99% of the stock, and they can't force a sale because the other class, the common stock, the founders class, has 1%, and if they don't approve it, it doesn't get sold. We get rid of all that in Delaware. So there's stuff like that. Plus, it also is a relatively favorable place in terms of fiduciary obligations. That's why we use Delaware. Now, with respect to the other issues, if you're doing business here in California, you're going to be taxed here. You're going to be subject to the laws relating to employment of the people you employ, We fight over that all the time. California courts always apply their own law on that issue to a California employee. You're going to be, what I just said about the privacy laws, if you're doing business here, you're subject to all this stuff. So it's really where the economic activity is.
So it doesn't matter where you store the data, it's where you actually...
Yeah, yeah. Oh, absolutely.
All right, thank you.
Okay, so my question is regarding the trademarks and also the logo. If you have a name and you know, say you're LLC, let's say the next big thing LLC, and you register it in California, do you need to register it in every state to guarantee that you can, I mean, it's a...
No, so trademark is a federal registration. States have registrations, by the way, and sometimes people do it. It's like a poor man's trademark, just to establish for the record when they were using a trademark. But trademark registration is federal, just like patents, just like copyrights. So you don't go and register in every state. Now, there are other rules. If you're using a fictitious business name, you got to do a filing in the counties of the states where you're using it. Stuff like that. But if you're talking about the trademark protection, that's just one federal registration.
What do you look at trademark and logo differently? Are they
A logo
different?
can't, okay, so a trademark is a fanciful mark or name or a distinctive mark, let me put it that way, distinctive mark or name. So a logo can be given trademark protection.
Okay, so, I mean, how do you, usually logo or trademark, they're graphic. How do you search for the uniqueness of those?
There's a way to do it. But you're gonna, first of all, you got some text associated with it, right?
Yeah, like the next big thing, LLC.
Okay, so first thing you're gonna
And
do
say
is...
that my trademark is a golden apple.
Yeah, so you're gonna look, well, that's why you do the patent and the trademark knockout search. There's a way you go online. And by the way, the examiners know how to do this. The examiners are gonna be searching those, those graphics files. If they find one that looks a lot like it, you'll be hearing about it.
Who are examiners?
Trademark examiners. When you apply for a trademark, you don't automatically get it, right? There's some examiner that's going to look at it, make sure you're in the right category, and
So
they make.
So it's a trademark application that you fill out and you apply it at the federal level.
Yeah, and you attach, samples and you attach samples and you attach samples of how you've used it in commerce, your letterhead, envelope, stuff like that, your website. So so people are looking at the actual graphic of it.
Oh, I see. How much does it cost to apply?
I should know that off the top of my head, but I don't. However, I do have a fixed fee list that covers trademarks I can give to you if you remind me.
Okay, thank you.
I probably shouldn't say it on video anyway, because it's just going to change. Oh, you will? Oh, okay, you should have told me that earlier. I told you guys all sorts of stories.
Hi, thanks for the presentation. Just a question regarding some of the legal issues that relate to if you're working at a company and then you want to start something that would be considered a competitor in terms of non-competes. What are the issues that relate to that?
To non-competes?
Yeah, non-competes and leaving a company that you're potentially going to step out and start something that could be considered a competitor.
Yeah, it happens all the time, and to the extent that you do that, the more careful you have to be about not taking any of your current employer's intellectual property. So let me tell you about non-competes, non-solicits, non-hires, non-intervention agreements. So in California, a non-compete is unenforceable unless it is entered into in connection with the sale of the goodwill of a business. So that means I can't get my employees to agree that they won't go work for a competitor. Court just won't enforce it in California. They will in Minnesota, they will in Texas, they won't here. So employees move very freely. So what do we as an employer do? Because, God, I don't want my employee to learn how to do this. I don't want to train him and he learns all this knowledge and he goes across the street to my competitor and he takes my list of accounts, and my God, I mean, he knows who my customers are, he knows their specifications, he knows my pricing, he knows, who I have to buy drinks for to get to buy, all this stuff. So we can't say you can't compete. We can get the employee to agree, however, that they will not use the employer's confidential information outside of the business. So they can't use that to compete. They can't use that to solicit customers. That's almost a non-compete. They can't use if I'm the employer, my company, they can't use that's a customer list. They can't use that to solicit people. There's something in there that's confidential, like a specification. They can't go across the street, take that with them and use it. So that's as far as you can go in California on non-competes.
Okay. Go ahead.
Obviously, just to follow up on that, what if the product or service you're offering is similar to the previous company you work for?
Question was, what if you're going to work, you're going to start your own company and you're doing a product or service that's similar to your current employer. So you're going to compete with your current employer. You're going to be very careful about not taking any of their confidential information, but you're still worried because it's very similar. Well, those are the cases when you have to be like really, really careful that you haven't inadvertently created some IP that belongs to the employer. And I've been in those cases for relatively high stakes because it's a hot business. And it can be very, very nasty. So the way it comes up almost always, we used to do this little dance, and I've gotten these letters and sent them. The letter is, Dear Nuco, we understand that you've just hired away from us our key employee, or maybe you're the founder even, whatever it is. We just want to remind you that key employee signed, a very expansive NDA with us where they agreed not to use our confidential information. And if he does, I'm going to come sue you, the company, because now you know. And then the company will send back a letter that says, well, yes, we're aware of that agreement, and we would never dream of using your confidential information. We're very careful about that. In fact, we made that new employee sign an agreement with us that says he's not going to use anything that belongs to you in our business. That's the little dance. Now, it has to actually be true. And where people get in trouble is those three things I just said at the very beginning. If it turns out they can prove you developed something, on their premises, on their time, or if it's the thing they hired you to do. And the cases I've had it come up have been a little more obvious. It's hard to prove this, but where I've been on both sides of this, but we have proof that you downloaded these files. Okay, we have proof. We got a record here. It says you went here and you downloaded this file on this and that date. That's our information, and so we got you. But otherwise, it's kind of hard to prove. But so you just have to be careful about CI in that case. Okay.
Hi. I have a question about corporate structure.
Get closer to the microphone. Closer.
You talked about converting LLCs to S corps and C corps. That's possible. How about nonprofits to for-profits? Is that?
We do a lot of nonprofit work. So what we worry about are there are rules against private inurement, but nonprofits, they spin off profitable entities all the time. I see that all the time. Let's use an example. You're a nonprofit, and damn, I'm being recorded, so I can't use a real example, so I have to make one up.
You can turn it off for a second.
Suppose your mission is to, I'm going to make one up, it's kind of close. Your mission is to help people get really good, underprivileged children to get education. You raise money to fund their education, and it turns out that you've gotten so good at this mission that that helping place these kids in schools, because you help them with like all sorts of things, how to find the right school, etc. You're so good at that mission that people will pay you for this service, and you realize, wow, we've got a profitable business here in a nonprofit. So that stuff, there's ways to spin that out, but we need to form a completely different entity. We need to divide up the asset, the IP. We need to have the appropriate licenses in place. They have to be fair market value, and there can be no different management teams, no private inurement. So that is possible, and we do it all the time. Usually it's the other way around, is that we're starting a business that has a real nonprofit component to it, because everybody's impact these days, right? So I'm going to start a business of, I've got this healthy food product that I've developed, but I'm also going to encourage forks over knives eating, and I'm going to save people from cancer and heart disease. So I'm going to form a nonprofit here and a for-profit, and people buy my recipes here, but they contribute to my nonprofit. So we have companies like that all the time that have nonprofits attached to them. You got to be really careful to draw the line and not have it, what we call private inurement.
So you're saying that it has to be completely separate?
It's separate.
So, but
Separate.
how about if you have, like you're saying that the core business is nonprofit, but there is something in that nonprofit that you can have for profit that you can use to.
Well, you can do one of two things. You spin it off. So a nonprofit.
You still need that original.
Well, here's the thing. Okay. So the nonprofit can operate a business. It's just going to be taxed in that business. But we have to be. This is maybe kind of a little more specific. Okay, I'll wrap it up. Two things. We drop the for-profit business into a new corporation that's wholly owned by the nonprofit. That way, because if you have too much business activity in a nonprofit, you lose the nonprofit status, because now its charitable mission is not the nonprofit anymore, it's the for-profit, so we drop it in a separate entity. That's one way, and that way and there's a lot of companies, a lot of nonprofits do that. In fact, the other way is you spin it off entirely and have a different group develop it, and just license the technology from the nonprofit. So you can deal with it, but you're absolutely right. You don't want to ignore it. You want to get the right structure.
So I have another question about corporate structures. So in terms of, and you gave a couple of examples where you may want to close the original company that you have. Say everybody's agreed on it, the founders are, they part friendly, everything, but 2 years from now you decide, okay, this is a product you want to develop again. What happens with that structure? Do you need to go back to the original?
You want to close it down and start over with a different product? I mean, that's the best way. You can use the shell for your new business, but then you carry all the old baggage with it. There might be contingent liabilities. So normally, that's why we have corporations, is to isolate liabilities and just put them away, when you're done. So I would start over with a new company.
So the original partners have no claims to the new business?
Not if it's a completely separate business. If it's something that the old business could do, then they do, but otherwise they don't.
Okay, we have time for one last quick question and a quick answer.
Okay.
Thank you very much for your talk. It was absolutely wonderful. I've only committed about 2 or 3 of those at this point. The one that's intriguing, though, is exempt. One of the things that I'm facing with somebody who's working with us at this point is that he's currently employed elsewhere. As soon as we get funding, he'll come over. He's an exempt employee, so one of the arguments that people will say, that employers will say is, well, an exempt employee works 24/7 for us.
Mm-hmm.
So in terms of that, you're never working on your own time.
Yeah.
What does the law have to say about that, particularly in California?
Yeah, I get that question once in a while. So then you just have to be really careful that they're not using company facilities. He's not at the office. I think, let me put it this way, I would look at it the other way. If there's a requirement that he be at the office from 8 to 5, then that's company time. I don't think you as a company are requiring, because I have non-exempt employees. I mean, it doesn't say in our contract that they belong to me 24 hours a day, 7 days a week, even though they might work that amount of time. I think I'd look at it the other way and say, if there's a company policy that says your normal business hours are this, then everything to develop during that time I'm going to argue for. So for someone like that, I think they just have to be careful not to use company facilities.
So if there is standard operating time frame at this point from like 8:30 to 5 p.m. in the employee contract, or rather in the HR manual, that would effectively...
Well, what I mean by employee hours are hours that somebody is obligated to be there on duty, So whatever the standard is.
Let's do that for Roger.
Oh, thanks.
So if you'd like the slides, email Roger directly.
Or give me a card and I'll send them to you.
And the video will be available on our YouTube channel in a few weeks, youtube.com/idea-IPO. So stick around, finish off the food, network, and see you next time.
And the ebook. Give me a card, I'll send it to you.